Welcome, everybody, to this next presentation in the series of Community of Practice webinars. Appreciate your taking the time to participate in this event. The purpose of these webinars is to offer practitioners of concepts and methods related to risk-informed and performance-based approaches, RIPB approaches we call it, a chance to share their knowledge and experience. I would expect that such practice is used for implementing nuclear technology and evaluating its safety. The Risk-Informed Performance-Based Principles and Policy Committee, RP3C, of ANS has been putting on these events for the past 3 years. Presentations and recordings of the events are available to the public at the ANS website under the tab RP3C. There are now about 40 such recordings available. The purpose of RP3C is to help modernize ANS standards. The Nuclear Energy Innovation and Modernization Act, NEMA, in 2019, associates modernization with application of RIPB approaches. There is growing realization within the nuclear community that conventional, prescriptive, and deterministic approaches are not going to support increasing use of nuclear technology to play its rightful role for the benefit of society. Socializing alternative approaches could drive changes in industry and regulatory practice. ANS offers the COP files on its website to serve as a knowledge repository of the experience from a wide range of practitioners in the field. We hope that more people will use this knowledge base to speed up needed changes in the state of the art as well as the state of practice. These events are generally scheduled for the last Friday of a month. Today, we will hear from Patrick White, and he is going to talk about a subject that is of a lot of interest to people involved in the licensing of nuclear reactors. This is the latest developments related to 10 CFR Part 53. And I let Patrick, introduce the subject and himself. Patrick, take it away, please.
Great. Thank you so much, Prasad. And thank you so much for the opportunity to present today here to the RP3C Community of Practice. So my name is Patrick White. I'm a research director with the Nuclear Innovation Alliance, and I've been actively involved on Part 53 over the course of the last 3 to 5 years. And so happy to kind of share some updates on kind of what's been the history of Part 53, what's the current status, and what are we looking at in terms of next steps. I like to joke for someone, if you haven't been following along for the last 5 years, this can hopefully get you up to speed and get an idea of what the next couple of years are going to look like, or what the next couple of years might look like as we start talking about the regulation of advanced reactors using a new regulatory framework. So to get started, I'll just give you a quick little bit of background about the Nuclear Innovation Alliance, my organization. So the Nuclear Innovation Alliance is a nonprofit, nonpartisan think tank focused on creating the conditions for success for advanced nuclear energy as a climate solution. We're primarily funded by private climate philanthropy organizations to help kind of identify policy solutions, technical solutions, and engage with different stakeholders to provide the information that folks need to really consider the deployment of advanced nuclear energy as a climate solution. So NIA is actively involved with the Nuclear Regulatory Commission to try to identify ways we can help improve the regulatory process to help ensure kind of the effective, efficient, and predictable licensing of advanced nuclear technology. So with that, I think it really kind of leads us into the main topic for today, which is how can we develop a new regulatory framework for advanced reactors that really enables this idea of effective, efficient, and predictable licensing. So in today's webinar, I'm really going to cover kind of 3 main topics. First is talk a little bit about the existing regulatory framework for new reactors. Where are we coming from in the United States? The second is to provide a brief history of the Part 53 rulemaking for advanced reactors. What activities have been going on at the NRC and with other stakeholders over the course of the last 5 years since the rulemaking kind of kicked off. and then provide some information on the current status and next steps on the Part 53 rulemaking process, and hopefully kind of identify where are opportunities where different stakeholders can get involved in the process and help continue to what's going to be an ongoing conversation on advanced reactor regulation. So to get started, we'll go ahead and lead in with the existing regulatory framework for new reactors. And one of the things that I think is really important to keep in mind is that the initial regulations in the United States were used to license a variety of different reactor technologies. While we think about the current fleet of existing light water reactors, primarily large light water reactors in the United States, as kind of being a symptom of regulatory and technological lock-in, early on in kind of the earliest days of the Atomic Energy Commission, the predecessor to the Nuclear Regulatory Commission, the applicants and staff really applied for, reviewed, approved, built, and operated a variety of different nuclear technologies. These included the Pathfinder nuclear generating station, which was a superheated boiling water reactor, the Hallam nuclear generating station, which was a liquid sodium and graphite moderated reactor, and even the Pequod nuclear generating station, which was an organically cooled and moderated reactor. These technologies are pretty different from the technologies that we operate today. And so it's interesting to think how the regulatory frameworks that were initially used really enabled this. And so if we take a look at kind of the history of nuclear technology, we really start to see kind of this optimization process over time that enabled the more efficient regulation of the dominant technology, large light water reactors. So while we start really with kind of the expert review-based regulation in the earliest days of the Atomic Energy Commission, when there wasn't substantial operating or regulatory experience, we started to see kind of the development of more kind of prescriptive and technology-specific items, starting with things like siting requirements for nuclear power plants, providing information on the general design criteria for nuclear power plants, developing the concept of standardized design basis analyses, and these really kind of formed the basis for a lot of the power plants that are operating today in the United States. Then over the course of kind of the 1970s into the 1980s and 1990s, we started to see growing interest in the potential impact of probabilistic safety analyses to provide insights on operational and design safety, a focus on operational safety program to kind of ensure continued safety after the initial licensing, construction, and operation. And especially in the wake of the Fukushima nuclear accident, a larger focus on the idea of kind of beyond design basis safety considerations and how to ensure the resiliency of nuclear power plants. And this has all kind of largely led to this idea of the Nuclear Regulatory Commission as being kind of this deterministic, technology-specific, and prescriptive regulator. And when we take a look at essentially what are kind of the bases of these regulations, from my perspective, it really comes down to this combination of design requirements, methodological requirements, and programmatic requirements. And when we think about the United States nuclear safety basis, really kind of sits here at the intersection of these three factors. And modern regulation in the United States, or current regulation in the United States, really uses all three of these. So for example, if we take a look at some of the requirements that are on new nuclear power plants today, if we start taking a look at, for example, the reactor coolant system, we can see that the existing regulations in 10 CFR Part 50 have specific design requirements on emergency core cooling systems, specific methodological requirements on how you evaluate, let's say, the deterministic loss of coolant accident evaluation models, and programmatic requirements on things like the reactor coolant safety valve test program. And the combination of these design factors, methodological factors, and programmatic factors are really what enable kind of the safe operation of nuclear power plants today. But these have all largely been optimized for large light water reactors. The challenge that we have moving forward is that if we use these same regulations for many advanced reactors, we may start to run into the need for having regulatory exemptions for many requirements. So if we just take a look at essentially these three examples of emergency core cooling systems, loss of coolant accident evaluation models, and reactor coolant safety valve test programs. If we take a look at just maybe, for example, three developers that are looking at developing different technologies, X Energy with a high temperature gas reactor technology, NuScale with their small modular light water reactor technology, and then Westinghouse here thinking about their heat pipe design, the Avinci reactor. These are three technologies that don't necessarily match one-to-one to these regulatory requirements that we have in existing regulation for new nuclear power plants. And so while you could use regulatory exemptions for these, it can lead to kind of a cumbersome and unpredictable process. And what the challenge that we really run into is, does this idea of having technology-specific, deterministic, and prescriptive regulatory requirements ultimately impede the new licensing of advanced nuclear reactors. While it is possible using the exemption process, and we're seeing that right now with some of the first movers going through the regulatory process, it might not necessarily be as efficient or as predictable. So if we think about the impacts of technology-specific issues, it might limit the licensing of non-light water reactor technologies. A focus on deterministic methods might limit the use of risk insights or applicability of risk insights when we think about design and operation. And if we start talking about prescriptive requirements, either on design or on programmatic operations, it could potentially eliminate technology innovation. And so when we start talking about a future regulatory framework, it's this question about how can we move to something that is more technology inclusive, risk informed, and performance based, with the idea that this can provide essentially a broader basis for nuclear regulation and enable the more effective licensing of advanced reactor technologies. Now, this idea of trying to think about a more technology-inclusive, risk-informed, performance-based process isn't new and is already being applied to the existing regulatory framework. So the best example here is to take a look at the Licensing Modernization Project, or LMP, that was created as essentially a methodology for licensing advanced reactors using the existing regulatory requirements and exemptions. And so this process was really the development of a technology-inclusive, risk-informed, and performance-based methodology that could be used to inform the licensing basis and the content of applications for non-light water reactors that are being licensed under 10 CFR Part 50 or 10 CFR Part 52. And so LMP was led by Southern Company and partnered with the industry's Advanced Reactor Regulatory Task Force to produce the industry guidance document NEI 1804 that outlined many of these processes. That included the selection and evaluation of licensing basis events, the classification of system structures and components, and then the determination of defense in depth adequacy. And this was all really being done from the idea of starting out at a technology inclusive, risk informed, and performance based process, and trying to help different applicants identify how that could be integrated into the existing regulatory rules using regulatory exemptions. The industry work and the work of, I think, maybe many folks that might be on the call today ultimately led to the support of NEI 1804 by the NRC staff and the endorsement in NRC Regulatory Guide 1.233 in 2020. And so this represents kind of an established methodology that advanced reactor developers could use to license non-light water reactors or advanced reactors under the existing regulatory framework in a way that is technology inclusive, risk informed, and performance based. But the challenge here is ultimately we're trying to fit it into a regulatory framework that has been largely optimized for large light water reactors. And so the question is, as we look to kind of the regulatory systems of the future, how could we try to develop a regulatory framework that more easily and natively integrates in this idea of technology inclusive, risk informed, and performance based regulation? And so that's what ultimately leads us to kind of the second section of this presentation, which is giving the brief history of the Part 53 rulemaking for advanced reactors. And one of the things I think is really important to remember is that when we talk about kind of 10 CFR Part 53, a lot of this work that we're doing on advanced reactor rulemaking really builds on decades of work by the NRC and other stakeholders on trying to develop more risk-informed, performance-based regulations. As we see kind of the development of probabilistic risk methods from the late 1970s on, in the mid-1990s, we see some of the first kind of formal NRC documents really kind of reiterating the idea of how to use probabilistic risk assessments in nuclear regulatory activities in 1995. Throughout the 1990s, we see increased support from the Commission for things like risk-informed and performance-based regulation. And then in 2003, we see regulatory guidance, the guidance for performance-based regulation, really come out as a way to try to show how can you start to implement some of these risk-informed and performance-based regulatory frameworks. Over the course of the rest of the early 2000s, we see papers from NRC staff and policy statements on approaches to risk-informed and performance-based requirements for nuclear power plants, and New Reg 1860 in 2007 that helped outline kind of a feasibility study for how you could develop a risk-informed and performance-based regulatory structure for future plant licensing. So there really is kind of this building of experience and building of conceptual, of kind of a theoretical and technical basis for how we could create a new regulatory framework. Over the course of the 2010s, you start to see kind of continued work on this topic. The NRC's report on safely achieving effective and efficient non-light water reactor emission readiness focused on the potential need in the long term to create a new regulatory framework that was technology inclusive, risk informed, and performance based. and then additional work by the Commission to really help outline how we can achieve modern risk-informed regulation for advanced nuclear power plants. And all of this culminates in the work that I already previously discussed with NEI 1804 and the NRC's endorsement of a regulatory guide that actually outlines how these types of processes could be used for the licensing of new nuclear power plants. And so when we talk a lot about what's going on Part 53, it's really important to remember that this is building on a large amount of work that's been done by a lot of folks both at the NRC and outside of the NRC. And that kind of helps provide the theoretical, technical, and even practical basis for new reactor regulation. So what actually started Part 53 and kind of formally kicked off this entire rulemaking adventure was the Nuclear Energy Innovation and Modernization Act, NEMA, that was passed in 2019 and directed the NRC to begin the rulemaking. So this was a piece of legislation that had bipartisan co-sponsors on the Senate Environment and Public Works Committee, EPW. It was passed by unanimous consent in the Senate and passed by an incredibly wide margin in the House of Representatives. It was ultimately signed into law in January 2019. And one of the provisions within NEMA, a bill that largely looked at NRC regulation and NRC regulatory modernization, was this requirement to actually develop a technology-inclusive regulatory framework. And I'll just go ahead and read it off, that no later than December 31st, 2027, the Commission shall complete a rulemaking to establish a technology-inclusive regulatory framework for optional use by commercial advanced reactor applicants for new reactor licensing. And there's some earlier discussion in the bill that talks about the need for it to be a performance-based and risk-informed process as well. And so this is really what kind of formed the basis for the NRC to start this process of developing 10 CFR Part 53. And so after essentially getting this kind of direction, the NRC staff began the process of actually developing a plan to complete the Part 53 rulemaking. And in the NRC staff's initial rulemaking plan outlined in SECI 20-0032, it provided their outline for how they plan to build on the LMP methodology and work that was previously done by internal and external stakeholders to serve as kind of the technical basis for a Part 53 regulatory framework. A couple quotes that are, I think, particularly helpful that when you take a look at the staff's rulemaking plan was that the focus of the rulemaking on risk-informed functional requirements, building on existing NRC requirements, Commission policy statements, and recent activities. And that the goal was to address performance requirements, design features, and programmatic controls for a wide variety of advanced nuclear reactors. So here I think you're already kind of setting a stage for what the NRC staff was planning to do with the rulemaking, even very early on in 2020. And this was ultimately going to be approved by the NRC Commission. They directly outline in the staff how they plan to use both the LMP methodology and the NRC endorsement of the LMP methodology as kind of key technical inputs to their development of a new regulatory framework. And I'll also say that they outline the desire to have as few connections as possible to Part 50 and Part 52, this desire to have kind of the rulemaking stand on its own, and to also engage in significant public outreach activities to a point that may be unprecedented in the development of this new rule, recognizing both the importance and the magnitude of the rulemaking process. And I think this is really important to keep in mind because as we see and as we'll kind of discuss the development of the Part 53 rulemaking process, I think it's really important to remember that this was the starting point for the NRC staff, and this is ultimately what the Commission directed them to do. And so while there might be some discussion later about stakeholder concern about the direction of the project, ultimately it was outlined very early on what the NRC staff's plan was and what they were going to be really focused on executing throughout the rulemaking process. So one of the things that we started to see, however, was that the initial plans for kind of the original schedule of the rulemaking started to get accelerated based on stakeholder and policymaker feedback to see the advanced reactor rule be developed more quickly. So the original schedule that was outlined by the NRC staff in their rulemaking plan was to begin their kind of proposed rule development, work through the latter half of 2023 on kind of preparing a proposed draft rule, providing a period for commission review and public comment, then have a period to incorporate public comment, make revisions to the rule, and kind of develop the final rule, have commission review that final proposed rule, and then publish the final rule in the middle part of 2027, ultimately meeting that NEMA deadline of completing the rulemaking by the end of 2027. Well, based on stakeholder feedback, there was this desire to try to accelerate it, to especially kind of match the moment where many folks were interested in kind of the more timely deployment of advanced reactors. And so the NRC ultimately ended up developing and improving kind of this accelerated schedule, where they would shrink the periods for proposed rule development to try to complete the rulemaking before the end of 2024. And this starts to come into play in terms of how much time the staff was being given to work on some of these topics, and potentially some of the scope that was considered as they started working through these initial questions of what would a new regulatory framework look like. And so through kind of this development process in the second half of 2020 and then into 2021, the accelerated proposal ultimately led to the development of a Part 53 that looked fairly similar to the LMP basis that the staff had initially said that they were going to use as kind of the technical background for Part 53. And so here you can see kind of a draft proposed rule outline that was given by the NRC staff during the summer of 2021 that gave kind of the general outline. And there are a few kind of key things that came up in those discussions. The first is that, similar to LMP, the NRC staff saw probabilistic risk assessment, or PRA, taking a leading role in the Part 53 regulatory framework, that there would be additional required licensing metrics based on the insights from PRA, and that they thought there were opportunities to have additional required plant operating programs that, again, would leverage many of the insights from PRA to give the operators more flexibility with their design and operations. And so this was kind of the initial plan for how Part 53 would be developed. Well, the NRC, because they were engaging in a very robust kind of public engagement process, started to get feedback and started to get, I would say, conflicting feedback from a number of external stakeholders regarding this use of PRA. Specifically, external stakeholder feedback was not uniform that an LMP-like framework was what all applicants would want. And instead, there was an interest in how to develop different application methods or different application methodologies that wouldn't rely as heavily on PRA, either in a leading role or rely on PRA at all. And so the NRC staff started the development of what was called the Part 5X supplement, or the Technology Inclusive Alternative Requirements for Commercial Nuclear Power Plants. And so the NRC staff looked through how could they develop a new regulatory framework that was kind of associated with this Part 53 rulemaking process that could leverage Part 50 requirements and could align more with international requirements for nuclear reactor licensing, kind of turning an eye towards long-term licensing harmonization. And the idea of this Part 5X was to create more options for the use of risk analysis in new reactor licensing, including kind of the enhanced PRA approach, more of a traditional PRA approach like we see in 10 CFR Part 50 and Part 52 currently, or then the idea of kind of developing this new methodology, a technology-inclusive, risk-informed maximum accident approach, or a TI-RI-MA approach. And I just have to say here for a moment, it's amazing the number of acronyms I think have developed out of this LMP Part 53 process. You'll kind of need your own alphabet to try to figure out all these different options. And so the NRC was really interested if stakeholders were pushing back on the use of PRA in an LMP-like methodology, how could they try to develop an alternative framework? Well, based on the additional work that would be needed to kind of formalize and develop this Part 5X, ultimately it led to an extension on the schedule. And so you can see here, there ended up being a revision on the schedule where they added essentially an additional 6 months to the rule development process and kind of stretched out the schedule to give NRC staff the time to prepare this Part 5X. And over the course of several months of work and public discussions, what we found was that NRC incorporated this more deterministic framework into a second licensing pathway. And the idea of the second licensing pathway is that it could incorporate existing innovations that were already found in the existing work that staff had done on Part 53. It more heavily leveraged Part 50 and Part 52 rule language. And this new licensing pathway was considered more compatible with international standards. It would also develop more unique, innovative licensing approaches, including how to use the traditional risk insights in both the licensing and operation. It developed a new approach called the Alternative Evaluation for Risk Insights, or ARI, and focused more on the development of principal design criteria for nuclear power plants, in contrast to what was done with the LMP methodology. And so this kind of new licensing pathway became known as Framework B, which means that the staff's existing work on 10 CFR Part 53 then became Framework A. And you now kind of had this multi-part rule. Part A would contain general provisions about the rule. Framework A would contain kind of the more traditional LMP-like methodology. And framework B would consider and contain this more kind of traditional deterministic or PRA in a trailing rule or confirmatory rule methodology. And ultimately, this results in the staff preparing their draft proposed rule and submission of the rule to the Commission in March 2023 for their review and approval. So I have here just a couple of the citations. The idea was that the draft rule was submitted to the Commission for their approval in SECI 23-0021. And one of the notes the staff made in the SECI was that Framework B would largely replicate the existing licensing approach in 10 CFR Part 50 and 10 CFR Part 52, but would modify it to be technology neutral. It ended up resulting, due to both the second pathway and the idea of not repeating regulatory requirements, or the idea of not of creating a regulatory process that was independent of the requirements in 10 CFR Part 50 and 10 CFR Part 52. It led to an extensive rule with a proposed draft rule Federal Register notice of 1,173 pages with additional supporting documentation and draft regulatory guidance. And you can see here on a right a slide from an NRC presentation from October of 2022, where the NRC staff kind of outlined the overall structure of the rule. And you can see here there's a lot of duplication between the two sections, with the idea that they wanted both Framework A and Framework B to be able to stand independently of Part 50 and Part 52 and stand independently of each other. And this was ultimately the rule that went to the Commission in March of last year for the Commission's review and approval. And that's now what brings us to kind of the third part of the presentation, is discussing the current status and next steps on the Part 53 rulemaking process. So one of the things that we saw both during the NRC's public comment period, where the staff was engaging informally with NRC external applicants, and during the more formal comment submission period, was that external stakeholders were expressing concern about the draft rule development and the direction of the rule during the rulemaking process. And kind of three major themes came up from a number of different external stakeholder groups. The first was that they thought that the Part 53 rule was too complex. The second was that they found it overly burdensome. And the third is that they felt that it had limited benefits. And some of the specifics there are as they felt that it was an overly lengthy rule with multiple frameworks, that there was too much material being included in the rule as compared to things that has historically been contained in regulatory guidance. There were uses of new terminology that didn't necessarily have regulatory precedent, and that they found a bit confusing that the NRC was constantly repeating requirements instead of just citing them. Again, I think it's important to note that this does align with the staff's original rulemaking plan to really say that 10 CFR Part 53 could stand alone from existing regulatory sections. So some of this kind of aligns with what we could expect the staff to do based on what their direction from the Commission was. The second part, when we talk about overly burdensome, some of the factors that were really addressed included the addition of new regulatory metrics, such as the formalization of the quantitative health objectives, or QHOs, in the rule as opposed to being part of a Commission policy statement. The addition of new operational program requirements. So one of the examples here is the facility safety program that helped look at kind of external hazards. While NRC staff stated that this could bring a lot of potential regulatory flexibility to applicants, it was a concern that it represented a new operational program. There were new requirements for design and licensing, and there were some prescriptive analysis and programmatic requirements. For example, the use of probabilistic risk assessment had a very fixed method within Framework A because of the insights that would be needed to generate to really support the rest of the licensing requirements in Framework A. And so it was really kind of seen as overly burdensome. The third category, when we talk about limited benefits, again, there were some concerns that it basically just replicated many of the requirements in Part 50 and Part 52, that improvement over the use of LMP using the existing methodology wasn't clear, that regulatory exemptions may still be needed, and as we kind of talked about earlier, the major goal of moving to a Part 53 framework was to eliminate the unpredictability and challenges associated with regulatory frameworks, and that there wasn't an understanding that Part 53 could improve the actual licensing timelines. And a lot of this really kind of led some external stakeholders to question what would be the benefits of using the Part 53 process over using an LMP methodology to support a license application under 10 CFR Part 50 and under 10 CFR Part 52. And so this led to, I think, a lot of things that the Commission and other stakeholders were considering as they were working through the process to evaluate the staff's proposed draft rule. Now, a quick aside to how the commission actually makes decisions, because this is a little bit important to kind of understand where we are on Part 53. So the commission voting process on any proposed draft rule, or really most any other issues, is a combination of public and confidential processes. It typically starts with the NRC staff memorandum to the commission, or a SECI, where it outlines a request from the staff for a commission decision or a commission vote on a specific topic. And this happens in public. It's publicly submitted to the commission. Then, confidentially, the individual commissioners work to develop their individual votes on the SECI. And so they can vote to approve, they can vote to disapprove, either in whole or in section, and provide specific comments, feedback, and direction to the NRC staff. And these are typically done privately by the commissioners and are held until the vote is finalized. But the commissioners have the ability to release their votes on any SECI at any time as they see fit. The next step in the process is that the commission secretary, and the commission staff will work to kind of negotiate and develop a majority position that can represent a majority vote of the commissioners kind of across various topics relevant to the SECI. And so this process, both the individual voting process and the development of kind of this majority position, can sometimes take weeks or months, depending on the topic and depending on the prioritization of the rulemaking and the vote by different commission offices. And so there's a bit of unpredictability in this process. Ultimately, that's also done confidentially, but the result of that are two public documents. The first is a majority commission direction to the staff, typically called a staff requirement memo, or an SRM, that represents essentially the commission's overall response to the SECI. And then also the complete commission voting record, or the CVR, the commission vote record, that provides the individual votes of the commissioners and helps provide some insight into what potentially led to the majority decision. And so these are two really important things that came up as we were looking at the Part 53 rulemaking process. The SECI was handed to the commission in March of 2023, and the commission offices then had an opportunity to start working through it and determine how they want to vote on the request to move this Part 53 draft rule from a draft stage into a public comment stage. That was what the commission was being asked to do in the relevant SECI. And so over the course of 2023, we started to see individual commissioners deciding to publicly release their votes on the proposed draft rule. And so the first vote that we ended up seeing was Commissioner Caputo releasing a vote on Part 53 that provided direction to the staff, or that would provide direction to the staff on how to reduce the complexity and scope of the rule. So at a very high level, we can think of the proposed draft rule as kind of being two components, Framework A and Framework B. What Commissioner Caputo's vote did at a very high level was sought to remove essentially the new regulatory requirements, many of the new operational programs that were contained in Framework A, make editorial and terminology corrections to Framework A, and help to simplify and clarify some of the existing requirements where there were some redundancies between Part 53 and existing parts of the regulation. And so Commissioner Caputo actually released a red line of the proposed Federal Register notice and outlined all the specific changes that NRC staff could make to try to create a rule that Commissioner Caputo thought would be more effective to kind of meet the overall need. Also, Commissioner Caputo, in her vote, voted to remove Framework B from the proposed draft Part 53 rule, but said that it should be retained for future Part 50 and Part 52 rulemaking to really leverage a lot of the thinking that NRC staff and external stakeholders are provided on the process. The result of this ultimately from Commissioner Caputo's vote would be a revised draft rule that represented kind of a simplified Part 53, more aligning with the key aspects of Framework A. And so this was the first vote that was released by Commissioner on the Part 53 SECI. The second vote that we saw publicly released was Commissioner Wright's vote on Part 53. And Commissioner Wright's vote really focused on providing direction to the NRC staff on how to really have a larger overall reorganization and restructuring of the rule. So again, if we start with that kind of proposed draft rule that was presented to the commission through the SECI, Commissioner Wright's vote really focused on how to revise some of the regulatory metrics and focus instead on how an applicant would develop and propose a safety case that demonstrates the safety of their technology generally, without necessarily prescribing any methods or analytic processes that would have to be used to try to meet regulatory requirements. Commissioner Wright's vote also would direct NRC staff to move much of the detail into regulatory guidance, and similar to Commissioner Caputo's vote, would help to simplify the rule structure and have many of the major sections essentially aligned throughout the rule. And ultimately, this would result in a much slimmer, let's say, restructured Part 53 rule, with large amounts of material that were both in Framework A and Framework B being moved into supporting optional guidance on Part 53. And so you can see here, there's an ultimately Commissioner Wright's vote was on the order of about 50 to 75 pages of direction to the NRC staff. And so you can see there's a pretty big difference there between Commissioner Caputo's vote, which was about 1,200 pages of kind of red line, versus Commissioner Wright's, which was more of kind of a high-level redirection of the NRC staff. And so the NRC commissioners then continue to work through the voting process throughout the end of 2023 and into the early part of 2024, with Commissioner Crowell and Chair Hansen providing their individual votes, and then beginning to work through that internal process of developing the majority position. And earlier this month, about 3 weeks ago now, we actually saw the commission release their vote and their staff requirements memo, their SRM on Part 53. And so what the NRC commissioners voted to do was to figure out how we could provide substantial direction to the NRC staff to modify the proposed draft rule from what they initially submitted up to the commission. And so the commission vote consisted of a few major aspects. The first was kind of a combination of what Commissioner Wright and Commissioner Caputo had publicly voted on, along with additional insights from Commissioner Crowell and Chair Hansen. Some of the major topics that they included were a revision of the regulatory metrics, a clarification on the use of PRA and risk information, a removal of many of the new regulatory requirements and operational programs, and then many of the editorial and terminology corrections and simplifications and clarifications that Commissioner Caputo and Commissioner Wright have both highlighted in their vote. They also decided to remove Framework B from Part 53 and instructed staff to provide another SECI with options on how they could incorporate a lot of the thinking and insights from Framework B into existing rules or into regulatory guidance. And the commission's vote on Part 53 have directed staff to essentially go back and revise this draft rule and create a new proposed Part 53 draft rule that could go out for public comment to continue in the rulemaking process. So let's talk a little bit about some of the specifics that went into this. Well, we can kind of go case by case to talk about some of the external stakeholder concerns about the content and direction of Part 53. So 3 of the topics, the role of cumulative health objectives, the role of probabilistic risk assessment, and quality assurance programs, the Commission directed within their SRM to make significant changes to these. So the requirement on complying with the cumulative health objectives, QHOs, were eliminated and were instead revised to instruct the staff to develop what were called comprehensive risk metrics, or a new way of trying to characterize the actual overall operational safety of a plant. The second was that the role of PRA in Part 53 for licensing was clarified, with the idea that it shouldn't be necessarily a checklist, but that applicants should include should include risk insights in their design and license process. And finally, with quality assurance programs, they eliminated kind of reproduced quality assurance programs or in 10 CFR Part 53, and instead align them with existing quality assurance requirements that exist in 10 CFR Part 50 Appendix B. And so here was more kind of a revision and clarification of some of the major issues. For some of the other topics, such as facility safety program, the requirement to include ALARA in your design, and Framework B, these programs and requirements and frameworks were largely removed or excluded from the staff's revised rule, or the direction to the staff on how to revise the rule. And overall, you can say that the NRC Commission really focused on how to overall simplify and shorten the rule, with a greater emphasis on rule flexibility. And so the Commission SRM really did try to identify a lot of the things that different stakeholders had identified throughout the public meeting process, and try to identify what a usable path forward would be. And so what that path forward actually looks like now is that the NRC staff are going to have 6 months to incorporate the Commission direction and prepare a revised rule for public comment. So we have our draft proposed rule on Part 53, SECI 23-0021. And now that we have an SRM, 2 things are coming into play. One, the NRC staff will have 6 months to directly incorporate the majority commission direction on Part 53, and that's what's outlined in SRM SECI 23-001. But also, the commission included, as kind of an attachment to their vote, the specific input that was provided by Commissioner Caputo and Commissioner Wright in their individual votes. And so the enclosures to the SRM instructed the NRC staff to consider the input that Commissioner Wright and Commissioner Caputo had provided, provided that it does not conflict with the overall direction of the SRM. So many of the specific items that both those commissioners brought up in their individual votes could be incorporated into the final proposed draft Part 53 rule. So the NRC staff will work over the course of the next 6 months to prepare a revised proposed rule with the goal of releasing that proposed rule for public comment by September. They're going to prepare the draft rule, and then they'll go ahead and release it for public comment by September 2024. And so if we take a look back at kind of that rulemaking process, what we're really going to be interested in the course of the next 6 months is any types of engagement with NRC staff on their revision process, and then looking forward to the formal public comment process that would start later this fall. And again, we can kind of take a look at this overall impact that even though the commission had taken a significant amount of time to vote on Part 53 and is requiring the NRC staff to make some significant changes to the rule, they still are on track to meet the NEMA deadline to complete the rulemaking by 2027. And so here you can see kind of a current possible schedule, and this has not been formally announced by NRC, but if you take into account the additional time required for the revisions and then looking at kind of the public comment period and the rule completion, you can see how it aligns on kind of on the third line there. So overall, I think really what we'll see kind of on the next steps on Part 53 is a focus on staff implementation of commission direction and really engagement with external stakeholders on addressing a few open policy questions that were left open during the SRM process and that some folks have provided questions about. So overall, we're first interested in just staff implementation of the commission SRM, and really try to figure out how external groups such as ANS and others can support and engage with staff on implementation of the commission direction provided in the SRM. And then on specific technical topics, there have been some questions initially raised about this idea of comprehensive risk metrics. Well, comprehensive risk metrics are not something that has been really discussed or used by NRC before, and so there are some questions from external stakeholders. What do they mean? How will they be developed? How will they be used? Some early indications suggest that they may be similar to the use of core damage frequency or large early release frequency, CDF and LRF, that we currently use as risk surrogates for light water reactors. And it will be interesting to see, are those types of metrics going to be appropriate for advanced reactors, or could we develop new risk metrics that really help NRC staff reach their determination of reactor safety? And so there are going to be opportunities to really collaboratively develop both the technical and policy basis for the comprehensive risk metrics for advanced reactor licensing, because that will be needed to support an effective Part 53 rule. The third major factor is security requirements. In the staff SRM, there were some lines about there were some specific directions to try to align the Part 53 security requirements with ongoing NRC rulemaking. And so it'll be important for external stakeholders to understand commission direction and the staff implementation of these updated security requirements to make sure they align with the idea of kind of a technology-inclusive, risk-informed, and performance-based regulatory framework. And finally, just more clarifications and reiteration on the expectations for an application PRA. One of the challenges that I think PRA is such a specialized field that people can either see it as intimidating or see it as only having one appropriate way to practice it, when the commission in their vote really focused on how to have PRA as a way of generating risk insights that allow for better licensing and better operation of plants. And so over the course of the next 6 months and then moving into the public comment period, we really see there being opportunities for understanding commission direction and staff implementation of the use of PRA in new reactor applications. So kind of in conclusion, as we start really kind of moving forward on this, we're really seeing continued stakeholder engagement on Part 53 as being critical to creating kind of this transformative rule for advanced reactors. We'll see the Part 53 regulatory framework should really be grounded by having a technology-inclusive, risk-informed, and performance-based framework that can really enable the effective, efficient, and predictable licensing of advanced nuclear energy in the 2020s and beyond. I think it's important to remember that we have not actually started the formal rulemaking process yet. We have not had an opportunity for formal public comments on this proposed draft rule. So we're still really early on, but it's really interesting to see how this process has really evolved over the course of the last 5 years, and even the last 30 years, if we take into account kind of the NRC and industry's continued thinking on risk-informed regulation, and how we can kind of effectively engage to make sure that we can ultimately support the development of a rule that meets the moment and really helps us license advanced reactors in a way that's effective, efficient, and predictable. With that, I thank everyone for attending the webinar, and I'm happy to have some opportunity for discussions and comments.
Well, thank you very much, Patrick. That was a really panoramic view of a lot of regulatory history over there, and got us caught up with the moment, as it were. So really appreciate that. I think we have a couple of questions in the chat. And so, Pat, maybe we can take it one at a time from the top.
Sure. Just make sure you can hear me. So our first one is from Ralph Hill, and he provides a little background and then as well as a question. So he just mentions that there were a lot of issues in using Part 52 for the AP1000 that had significant negative impacts. And he's questioning what are the lessons learned that can be applied to the implementation of Part 53.
Yeah, so I think there we've seen a lot of work by the NRC Commission and by external stakeholders really kind of address what were either, I think one of the challenges sometimes thinking about the lessons learned from Part 53 is, are those specifically regulatory requirements that we see in the rule itself, or is it more challenges in the implementation of those rules? When we think about construction oversight, when we think about the amendment process, and how we think about how applicants can kind of engage with the regulator. So I think there are some lessons learned that would be incorporated into Part 53 from the AP1000, but I don't have any off the top of my head. But I know this is kind of an active topic for NRC to keep in mind as they take a look at kind of implementing these reactor regulations, and remembering there are a lot of things that will affect the application and licensing process for a reactor that aren't necessarily included in the regulation itself. What goes on in regulatory guidance? What are the internal commission practices and procedures and expectations? So I think there are a lot of different opportunities there to kind of make sure that we're incorporating some of these best practices, both on the applicant side and also on the regulator side.
Thank you. So we'll go on to actually a couple questions from Randy Franovich. First one is on slide 6. I don't know if you want to see if you can't find that slide while I go ahead with a question. She says, slide 6 does not include reference to the Commission policy in 1999 to implement RIPB approaches to regulation and oversight. How has that policy been implemented in the intervening 25 years, and what are the implications of this for Part 53?
Yeah, it's a great question, and I really appreciate it, Ronnie. I think I might have to kick that to maybe some folks that are more informed on kind of how RIPB has really been impacted on the reactor oversight process, because I know for much of the existing fleet, that's where we've really seen some of the impact of RIPB. In terms of the implications on Part 53, I think you can probably talk about how it is trying to figure out where are the cultural gaps of, has RIPB really kind of been fully embraced by staff, or are there still need to kind of help staff understand or help staff work through some of the challenges of what does it mean to have kind of a risk-informed regulation. So unfortunately, don't have a great answer to what's a very good question. And I think I'm seeing now in the chat, there are a couple of additional questions from Ronnie in terms of, features of LMP that make it performance-based. I believe there it's kind of starting to kind of talk about LMP, for example, will make use of risk consequence curves or frequency consequence curves as a way to try to demonstrate what is the actual impact of different licensing events on plant safety. And so in my mind, that's where it becomes more kind of a performance-based regulatory requirement, because we're tying it to an off-site dose metric as opposed to kind of a prescriptive metric on design or operations. And then very much appreciate the typo catch, I think, on slide 12 with SRM SECI 98144 as opposed to SECI 9814. So I appreciate that, and we'll definitely have that corrected in the slide. So thanks for the keen eye there, Ronnie.
And then we also just have a thank you from Ralph Hill, just that thanking you for a well done presentation. Same thing from Ronnie. And it looks like we've got a last question from Greg Hudson. He has asked, how was the experience of other regulators, that being from the UK, ONR, incorporated, and such?
Yeah, it's a really good question. And I think we're seeing it kind of among the different views of the commission and how they really think about kind of what Part 53 could look like. I think when you talk about kind of an LMP-based methodology, what we saw in Framework A a lot of that was kind of leveraging the thinking and processes that we saw in kind of existing US regulation. And so maybe it wasn't necessarily getting into the regulatory experience or regulatory philosophy of other regulators. I think if we take a look at Commissioner Wright's vote, this idea of kind of a safety case or a really kind of performance-based methodology ultimately is closer tied to kind of international regulators like the UK ONR or the Canadian CNSC of an applicant bringing a safety case and demonstrating compliance with high-level performance-based regulatory requirements. And so I think when we talk a little bit about kind of the implementation and the inclusion of Commissioner Wright's vote, that starts to kind of point to some of that international experience. One of the things that we see on the comprehensive risk metrics, for example, is that the commission did not necessarily direct the staff to develop one comprehensive risk metric for potential applicants. Instead, what they really instruct is that applicants should work with NRC staff to develop their own risk metrics or have the option to develop their own risk metrics that make sense for their technology. And I think there it really kind of gives us the opportunity for an applicant to say, okay, between a high temperature gas reactor, a sodium fast reactor, a molten salt reactor, or light water reactor, there might not be one specific comprehensive risk metric that works really well for every technology, but how can we identify what is a specific risk metric that makes a lot of sense for that specific design or that specific technology type? One of the things that I'm really hopeful that we can do on kind of the comprehensive risk metrics specifically moving forward is try to develop risk metrics that really align with the design and analysis work that applicants are already doing. I think as we start talking to different advanced reactor developers that are in the space and experts that work a lot on kind of probabilistic risk assessment and design methodologies, they're doing a lot of these calculations. They're coming up with risk metrics. They're really prioritizing different aspects for design and operation. And how can we determine and develop a risk metric that ultimately is something that an applicant is already doing as part of their kind of best practice for design and isn't an additional set of calculations that they need to perform just to meet a regulatory requirement? And really kind of integrating this idea of licensing into the design process to try to kind of reduce that regulatory burden and have kind of a more streamlined, effective, and efficient regulatory system.
Thank you.
See,
So
I
we
think
do.
there was another question from Ralph.
Got that one from him. He's asking from a harmonization perspective, have discussions been held with other regulators relative to Part 53?
That's a great question, Ralph. I'm not sure if formal discussions have been held or if they've been more informal. I know the Nuclear Regulatory Commission currently or has had a long-standing memorandum of understanding with the Canadian CNSC on trying to kind of align regulatory harmonization. And I believe at the RIC, it was announced that they have now kind of opened up that memorandum of understanding to include the UK ONR. But one of the challenges that we really run into is just kind of this idea of the historic basis for the different regulatory systems, where the US is really coming from a more kind of prescriptive, performance-based, and technology-specific regulatory framework, as compared with UK ONR and CNSC that have more of this safety case-based methodology. And so this idea of a regulation being very slim and then an applicant having to propose and demonstrate how they meet it is a bit of a mental shift, I would say, for maybe some folks at the NRC, just because it's very different than what the agency has historically done. So I imagine the discussions have occurred, but I don't have any specific insights on potential collaborations between the NRC and external stakeholders or international stakeholders on Part 53.
Okay. Patrick, I guess in the last couple of minutes we have, I'd like to ask you if anything stood out in the SRM and all its different parts as being a significant change in commission policy regards any aspect of regulatory practice or what we can expect will be competing regulatory frameworks, as it were, because applicants, developers will have to make choices. And does anything stand out to you as recommending Part 53 for its use as compared with the others?
Yeah, that's a great question, Prasad. I think a lot of it will be based on I would say the experience of some of these initial advanced reactor developers as they're moving through the existing Part 50 and Part 52 process using LMP-like methodologies. I believe TerraPower just announced today that they had submitted their construction permit application to the NRC, and I believe they're leveraging an LMP-like methodology under 10 CFR Part 50. And so I think as more developers kind of move through the existing rules, we'll see, are they running into challenges with either novel uses of regulatory analysis methods, like moving away from PRA and maybe using more deterministic methods? Are they looking at implementing kind of novel operational programs that would require such significant exemptions it may be challenging to get through the licensing process? Or are there potential opportunities afforded to them in 10 CFR Part 53 to maybe use a more novel approach for a reactor technology that might look very different? Are there creative ways you could license a 1 megawatt heat pipe microreactor that completely kind of change the way that we think about the safety analysis and design and operational requirements as opposed to a 1,000 megawatt light water reactor? I didn't necessarily see anything in the SRM that made me think it was kind of a major shift in commission policy. But I do think that the commission push to kind of go for the comprehensive risk metrics is a really interesting case, because I think it is something that starts to kind of push more towards performance-based regulation, kind of the safety case-based regulation. And it's something that industry, the NRC, and other external stakeholders are going to have to work through together, because it represents, I think, a really unique opportunity to move towards more performance-based regulation. But if it's not implemented correctly, it potentially could be a large, significant new burden to advanced reactor developers. And so I think there's going to be a lot of opportunities and kind of a lot of work that can be done by all groups to make sure that that ends up becoming an effective regulatory frame or an effective regulatory requirement that enables better licensing, as opposed to being essentially a regulatory burden that's going to slow down and inhibit licensing. So overall, yeah, I mean, I think we were excited about it, but it'll really come into seeing what the implementation process looks like and what the details ultimately end up with in the proposed rule later this fall.
Oh, do we have time for one more question?
I'd be happy to take one more.
Okay.
People don't mind sticking on an extra minute or two.
Okay, so we have a last question from Paul Amico, and he just wants to know if you're aware of the EPRI project that is looking at the non-light water reactor PRA needs, which includes looking at appropriate risk metrics. The EPRI project manager has taken note of the risk metric item in the SRM and is making sure it is taken into consideration in the EPRI project. No,
that is really helpful. I actually heard about that for the first time at this at the Regulatory Information Conference just even a couple of weeks ago, and so I think it's a thing that NIA and other groups are going to be really interested in following up on, if only because solving cumulative risk metrics and comprehensive risk metrics, it's a hard challenge. I mean, I can say personally, I've spent a lot of time trying to think about how you could calculate these risk metrics, and it's a hard question. And so getting as many experts with different views, lots of experience, and lots of different perspectives on it is ultimately going to be critical to really figuring out how can we create something that is going to be a good risk metric. So thanks so much for flagging that EPRI project. And I think that's one that I know at least I'll be following up with over the course of the next couple of weeks to see what kind of insights they bring into it. Oh, and it turns out we've got Eric Thornsberry, who is the EPRI lead on that project. So Eric, I think you can expect an email from me in the coming weeks on that. It'll be great to find some time to discuss it with you.
Yeah, thanks a lot to everybody for active participation in this. And Patrick, great presentation. Really appreciate your contribution to get everybody caught up. Pat, I think that's about it. I guess, again, thanks to all of you.
And there's one more question that came in. I'll make sure we get that to Patrick and try and get that to the individual. So thank you all very much. For those of you that celebrate Easter, happy Easter, or have a great weekend. Thank you, and have a good day. Bye.
Great. Thank you so much.
Thank you all.